Okay. Buenas tardes. I want to begin by thanking Laura for inviting me to speak to you today. I actually have a Spanish version of this talk. However, when I spoke, I first met Laura in Porto Alegre, Brazil, where I spoke at the Federal University of Rio Grande do Sul, and Laura pointed out that there were several errors in the Spanish translation of the Spanish version of my lecture, which she was correct about, and I have fixed those. But to be on the safe side, I'm going to speak in my native language of English with the occasional Latin quotation, and I hope that the errors are substantive only in nature. So this is the 800th anniversary of Magna Carta, the Magna Carta of King John, Juan Sin Tierra, as he's known in the Spanish-speaking world. And there have been many lectures, many conferences, and events held in connection with this, especially in the United Kingdom, but also in the United States and other parts of the world. And there has been so much attention given to this anniversary that some people have started to argue that we are spending too much time talking about Magna Carta. And the day that the anniversary occurred, or around that time, there were two editorials in the New York Times, both making the argument that Magna Carta is not as important as some people think it is, and we shouldn't be spending so much time talking about it. And I think that there was some truth in what they were saying. However, some of the arguments that were made were rather fallacious, starting with the notion that Magna Carta 1215 was not important because the Pope annulled it 2 months after it was issued, and therefore it didn't last very long. Well, that's true, but it was reissued by John's son, Henry III, in 1216, in 1217, and in 1225, with most of the provisions intact. And some of those provisions remain valid law in England today. So the idea that somehow it wasn't important just because it was temporarily annulled, or the first version was annulled, it seems to me a silly argument. Another argument that is made, which I think is also incorrect, is that Magna Carta was only important to the most powerful people in England. It was only important to the barons and not to the common people. And as I'm going to show today, that is also not correct, because there were a number of provisions in Magna Carta that were important not necessarily to everyone in England, but to a much broader swath of society than just the barons who actually presented their demands to Magna Carta. And I'll go through some examples of that. However, there is one point that was made by some of these critics, which is valid, and that is that one of the things that Magna Carta is most famous for, at least in the United States, is something it didn't actually do, and that was to provide a guarantee for jury trial in criminal cases, because there was no such thing as a jury trial in criminal cases in June 1215. So today, the way I'd like to approach this topic is to begin by discussing what everyone acknowledges as important, and that is the myth of Magna Carta, or the legend of Magna Carta, and how powerful a symbol Magna Carta has been throughout history, especially in the Stuart period of England and in the American Revolution. Then I'm going to talk about what Magna Carta actually meant in 1215. And I will make the argument that it wasn't just the myth of Magna Carta that was important. Magna Carta was important in 1215, and it contained provisions that were important at the time, enough to warrant being reissued multiple times, and that its success can be attributed to two main factors. One is that it reflected a strategic compromise between competing interests, and the second is that it contained specific and concrete guarantees of liberty, that it was not just a broad statement of rights, but there were very specific things that were promised in Magna Carta. In the third part of my lecture, depending on how much time we have, I'm going to talk a little bit about some of the research for my book, which Laura mentioned, explaining how jury trial came to be used in civil cases for certain types of property disputes, and why that institution of civil jury trial was considered important enough to be protected indirectly by certain provisions of Magna Carta. But let's begin by looking at the impact of Magna Carta in history as a symbol. What you see here is an image from a door entering into the U.S. Supreme Court building in Washington. And this is one of several images depicting famous events in the history of law. And this, of course, is King John putting his royal seal on Magna Carta. It's nice that, unlike many other depictions, this does not have John signing Magna Carta, but actually putting his seal on Magna Carta. Magna Carta has always been a powerful symbol since the time of independence in the United States. But its role as a symbol goes back to the Stuart period of England, when the Stuart kings were asserting the right to rule by divine right, that they had God's sanction to rule. And the critics of that position, especially Sir Edward Coke, pointed to Magna Carta as an example of the principle that kings did not rule only by divine right, but subject to the rule of law. That inspiration then led some of the American colonists to cite Magna Carta in defense of their defiance of the British Crown. And so, for example, when the colonists objected to some of the taxes that were being imposed by the British government on the colonists in the Americas, or in North America, they pointed to Magna Carta in saying that these statutes are not valid because they contradict this more fundamental law that precedes the power of Parliament to rule on these issues. Because otherwise, if you couldn't point to something other than acts of Parliament, there was no basis to challenge the validity of these acts, because Parliament could legislate on any subject it chose to legislate on. They didn't have the kinds of written constitutional restrictions that we have now in the United States. But they pointed to Magna Carta as an example of the power of the government being limited by law. Here we have a quotation from Samuel Adams saying, "An act of Parliament made against Magna Carta in violation of its essential parts is void." And then we have an image, this is from the Great Seal of Massachusetts, where we have the patriot holding Magna Carta in his left hand and the sword in his right hand, preparing to defend his country by force or by law. This interest in Magna Carta also had an impact on the first constitutions in the United States. Not only with the federal constitution, but before that with the first state constitutions, which were adopted in 1776. Some of the original state constitutions contain verbatim quotes from Magna Carta 1215, especially these two provisions on the left, which are translated into English here. "No free man is to be arrested or imprisoned or disseized or outlawed or exiled or in any way destroyed, nor will we go against him, nor will we send against him, save by the lawful judgment of his peers or by the law of the land." And clause 40, "To none will we sell, to none will we deny or delay right or justice." If you look at some of the first state constitutions in the United States, you'll see these two provisions quoted word for word. The federal constitution does not quote those provisions verbatim, but it does contain some language, at least in the Fifth Amendment, that is parallel to clause 39. So the Fifth Amendment to the U.S. Constitution starts by saying, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury," and then it goes down to say, "nor be deprived of life, liberty, or property without due process of law." So you can see that both of these provisions begin with the word "no." They say what no person or no free man, in the language of Magna Carta, can be forced to submit to unless you follow the law of the land or due process of law. So even though the language is not identical, there is an obvious influence. And that influence is coming not only indirectly from Magna Carta, but also through the state constitutions that quoted that language. But it wasn't just in the United States that Magna Carta has had a powerful impact as a symbol. If you go to the actual site at Runnymede, where Magna Carta was sealed, there are two monuments there from the United States American Bar Association. But there's also a monument from the Republic of India. And the Republic of India has also had a respect for Magna Carta. Going back to when Gandhi, who of course was the father of Indian independence, before he left South Africa, was praising a certain statute that had been adopted by Parliament to protect the rights of Indians in South Africa as our Magna Carta, talking about the statute, our Magna Carta, because it marks a change in the policy of the government towards us. It moreover confirms the theory of the British Constitution that there should be no legal racial inequality between different subjects of the crown, and it has vindicated passive resistance as a lawful clean weapon. Now, the Indian Relief Act may have done those things, but Magna Carta certainly did not do those things. And this may be one of many instances where Magna Carta is being cited in defense of something totally different from what it accomplished. Legal racial inequality is not mentioned in Magna Carta at all, except in some provisions that limit the rights of Jews to collect their debts. So it's the opposite of what Gandhi is talking about. And passive resistance is the opposite of Magna Carta. Magna Carta was armed resistance against the king, and I'll talk a little bit more about that. But it's not so much the details of Magna Carta that are important as the concept that the government is subject to these fundamental principles that Gandhi is citing here. Gandhi, of course, was trained as a lawyer in the UK before he went to South Africa. So the women's suffrage movement also cited Magna Carta. At the left here, we have a quotation from a suffragette magazine, a newspaper, saying, "The right of the franchise is still unconstitutionally withheld from women, but the spirit of Magna Carta sounds a trumpet call to them to struggle ever more valiantly to realize its noble ideal." And then at the right, there is a illustration from a similar magazine about votes for women, advocating for the right to vote for women, showing the barons presenting King John with their demands. And the relevance of Magna Carta for the women's suffrage movement was, obviously, if the goal is to get women the right to vote, that goal cannot be accomplished by having women elect representatives, because the whole point was they did not have the right to vote for their representatives. So instead, you had to get the government to act by other means, by putting pressure on the government. So that's why Magna Carta was an important symbol for the women's suffrage movement. And another example, this is actually literally using the symbol of Magna Carta to promote the cause of justice. Winston Churchill, faced with a grave threat to Britain in the form of the Nazi air assault on Britain, is trying to get the Americans to enter the war. The Americans have not entered the war until the end of 1941, when the Japanese the Japanese government bombed Pearl Harbor. But there was a copy of Magna Carta that had been loaned to the New York World's Fair, which started in 1939. And that copy of Magna Carta was stuck in New York because they couldn't take it back during the war, because the German submarines were patrolling the North Atlantic, and there was a risk that if they brought it back, it would be sunk. So they had left it over there temporarily, and this proposal was that the British government would give this copy of Magna Carta, this original copy from Lincoln, to the United States as a gift to remind the United States of our shared commitment to rule of law and principles of justice, and thus encourage us to go to war against Nazi Germany. And it was taken very seriously at the highest levels of the British cabinet. The reason why it didn't happen is because the British government didn't actually own this copy of Magna Carta, and it was owned by Lincoln Cathedral. And Lincoln Cathedral didn't want to give it to the United States, and it would have been somewhat inappropriate given what Magna Carta was about, to take it away from Lincoln Cathedral without their consent. So it didn't end up happening, and then of course when the United States enters the war anyway, it becomes a moot point, and they just hold it for them temporarily. But the idea that this parchment, this old manuscript, could be powerful enough to induce a nation to go to war is amazing. That they thought that this document could have that effect on people. And then a final example of the international relevance of Magna Carta in recent history, Nelson Mandela, when he gave his speech at his trial for being one of the leaders of the African National Congress, said that the Magna Carta, the Petition of Rights, and the Bill of Rights are documents which are held in veneration by Democrats throughout the world. I have great respect for British political institutions and for the country's system of justice. This was in his famous speech, which ends with the words, "I am prepared to die." And at this time, he was trying to distinguish the ANC from the Communist Party and the Communist movement by showing that the ANC was committed to the basic principles of democracy and the rule of law. And of course, when he becomes the first democratically elected president of South Africa, he follows through on this, and he does allow South Africa to continue to be a democracy governed by rule of law. So everyone would agree that Magna Carta has been a powerful symbol of justice in many different contexts in history. And regardless of its original content, it is worth celebrating the 800th anniversary, if for no other reason than because of all the many other pivotal moments in the history of law and the history of justice that have been influenced by Magna Carta. But what I would like to talk about is why Magna Carta was actually important in 1215, and to make the argument that it was important in 1215 for reasons that have remained important up to this day, even if the specific provisions that were contained in the document in 1215 are no longer significant. So let's begin with the political context of Magna Carta in 1215. This is a map that shows the territories that were controlled at some point by John's father, Henry II, and then his older brother, Richard. This was referred to as the Angevin Empire because one of the territories, and I can't see this well enough to find, I think this is it here. This is Anjou. One of the territories that was controlled by Henry II was the county of Anjou, which was part of his inheritance. He also controlled the Aquitaine through his mother, Eleanor of Aquitaine. And so these English kings, Henry II, Richard, and at the beginning of his reign, John, controlled this vast territory in France. Now, in France, they did not rule as kings. They were vassals of the King of France. And the King of France was always resentful of this because even though the English kings were his vassals for their French lands, they had much more power in reality because they controlled so much territory, and they had their own kingdom of England. Plus, some controlled a significant part of Ireland as well. So this was called the Angevin Empire, even though it wasn't an empire in the technical sense. It didn't have an emperor. But when John became king at the death of his brother Richard, he inherited all this land. And there's a recent translation of Magna Carta by David Carpenter, a British professor, which is an excellent translation and also contains a detailed commentary about Magna Carta and its context. And Professor Carpenter makes an excellent point that it is quite appropriate that Magna Carta begins with a recital of all of these French territories that John claimed to control, although at that point he had lost them, and I'll explain why. Because it was, more than anything else, it was John's desire to get back his territory in France that produced this document that was ultimately the cause of Magna Carta. So the document begins, John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Aquitaine, and Count of Anjou, to all of these various archbishops, bishops, abbots, and other officials, greeting. So he had controlled all of this territory at the beginning of his reign, but he had lost it by making some foolish decisions, what in sports they would call unforced errors. And the first of these was his decision to marry Isabella of Angoulême, depicted at the right here by some Victorian artist. The problem with he decided to marry Isabella of Angoulême, a French noblewoman, because he wanted to have greater control of this strategic county in southwest France. The problem was, well, there were two. One was that John was already married to someone else, and you weren't allowed to be married to two people at the same time. He solved that problem by getting a divorce. But the bigger problem politically was that Isabella was engaged. And she was not just engaged to anyone, but she was engaged to one of the most powerful men in France, Hugh de Lusignan. And by marrying Isabella without compensating Hugh, John was acting against the norms that applied to the feudal aristocracy in Europe at this time. The appropriate thing to have done if he wanted to marry a woman who is engaged to someone else would have been to offer some compensation to Hugh, because Hugh probably also was interested in Isabella, at least partly because of the land that she controlled, and to offer some other land to Hugh to compensate him or something. But he didn't offer Hugh anything. He just decided to marry Isabella. So Hugh has a grievance against King John, and he takes this grievance to Philip Augustus, the King of France, and says, John has married my fiancée and has not compensated me. And Philip says, this is terrible. I sentence John to forfeit all of his continental possessions, because Philip did not want John to have any of this land on the continent anyway, and this is a perfect excuse for Philip to get it back. So he sentences John to forfeit all of this land, and then he proceeds to execute his sentence by conquering one by one all of John's French territories, including the Duchy of Normandy, which was a very important strategic, not just strategic, but symbolic possession, because it had been the location from which John's ancestor, William the Conqueror, had invaded England in 1066. So if John had been content to try to win back Normandy, he might have succeeded. But he wasn't content with that. He wanted to win back all of his continental possessions. And in order to do that, he had to raise feudal dues to raise money for an army of mercenaries to invade France. And during the time that John was king, there was significant inflation in England. So he would have had to have raised feudal duties just to keep up just to maintain the revenue at his level of expenses. To win back these lands by raising an army of mercenaries, he had to increase them even more to unprecedented levels. Now, Richard, John's older brother, had also been responsible for some increases in feudal dues, but those were accepted because Richard went on crusade, and he was famously fought against Saladin in the Holy Land. And one of the causes of raising the dues was to get him ransomed on his way back from the crusade. John, by contrast, was going off on this mission that most of the barons in England were not that committed to. They would have been committed to a greater extent if he were just trying to win back Normandy, because they also had possessions in Normandy. But there was no interest group that was in England that cared about John recovering these other territories in France. So he goes on his invasion. It is unsuccessful. He doesn't win these lands back. A group of rebel barons decides to march down into London. And they manage to get themselves invited into the city of London, where they have an almost invulnerable protection against any attempt by King John to dislodge them, because the city of London is so well protected by its walls, by the wealth of the city and its size. They present their demands to John, and John, who is now in an untenable situation, has to agree to their demands. So he agrees at this famous moment, and here he is holding the pen, which he certainly did not have, agreeing to this document. It was not called Magna Carta in 1215. That name was acquired 2 years later when Henry III reissued the document, but also issued a separate document called the Charter of the Forest, which guaranteed the people the right to be protected against encroachments of the king's forest. So it came to be called the Great Charter later on to distinguish it from the Charter of the Forest. But among the provisions of the Magna Carta 1215, the two most famous are Clause 39 and Clause 40. And I read you the English before, English translation. The original Latin says, nullus liber homo capiatur, vel imprisonatur, aut disseisiatur, aut utlagatur, aut exulatur, aut aliquo alio modo destruatur, nec supereum ibimus, nec supereum mittemus, nisi per legale judicium parium suorum vel per legem terre. Nulli vendemus, nulli negabimus, aut differemus rectum aut justitiam. I think this sentence here is probably one of the most famous quotations in all of the history of law. I worked at a federal courthouse in Colorado when I had graduated from law school. This was actually inscribed on the side of the building in Latin. They had these words. They had to shorten it. They took out nulli vendemus, so I guess they didn't make a statement about selling justice, but denying and delaying justice was inscribed on the side of the building. So these two provisions have led some to believe that Magna Carta was protecting the right to trial by jury, because it speaks about the lawful judgment of his peers. William Blackstone thought that this was a guarantee of trial by jury in criminal cases. And his view influenced many justices of the U.S. Supreme Court, who subsequently cited Blackstone and Magna Carta for the idea that this provision guaranteed the right to trial by jury. However, that is obviously incorrect, because prior to the Fourth Lateran Council, which happened later in 1215, the mechanism for resolving criminal trials was the ordeals. This was one of the points that Laura pointed out. I translated this as tortura, which of course is not accurate. It is ordalia, would be the correct, am I right, translation in Spanish. The ordeals were used to invoke God's judgment to decide guilt or innocence. One of the ones that was used quite frequently was the ordeal of hot iron, where this hot iron is put into a person's hand, it burns the hand, and then they bandage it up, and 3 days later they open it to see if it has become infected. If it has become infected, he is guilty. If it has not become infected, he is innocent. And if he's guilty, he will be executed. If he's innocent, he will be exiled, because they didn't have that much confidence in this system. The reason why they had any confidence in this was because the priest, as seen in the left here, is saying a priestly benediction over this and is invoking God's judgment. And if God is approving this, if God is blessing this, then if the man is innocent, there will be a miracle, and his wound will not become infected. What happened later in 1215 was Pope Innocent III in the Fourth Lateran Council said that priests would no longer be permitted to participate in the ordeals. And from that point, it was actually the case that jury trials were used in criminal cases. But at the time of Magna Carta, it was not the case. It would have been impossible. So it is accurate to say that Magna Carta's role in protecting criminal jury trials is false. And to that extent, I agree with those who have criticized the celebrations of Magna Carta 1215 as being overblown. However, there were other aspects of Magna Carta that were important in 1215, and I would argue that these other reasons why Magna Carta was important in 1215 remain important today. First, Magna Carta reflected a strategic alliance between competing interest groups. It was not just the product of duress that was imposed by the barons on the king, although it wouldn't have happened without that. It reflected an alliance of different interest groups, starting with the church. That even though at this point King John had made his peace with the church, and England was no longer under an interdict. In fact, King John had agreed to give England to the Pope to be held as a fief, a papal fief. So there was, at this point, he has worked out the differences with the church that he had earlier in his reign. But Stephen Langton, the Archbishop of Canterbury, knew that King John was not very trustworthy when it came to matters especially involving the church. So he played an important role in mediating this dispute between the barons and King John. And as a result, Clause 1 of Magna Carta repeated a promise that John had earlier made to respect the rights of the English church. And that was included in the Charter of 1215, and that's another provision that has remained in place to this present day. Secondly, the City of London, which of course played a crucial role in sheltering the barons, protecting them when they invaded England, or when they came down to London to attack King John. The City of London had a prominent place in the Charter. In addition to this general provision, which said that its ancient liberties would be respected, there were several other more specific provisions, including ones relating to standard weights and measures, and another one relating to fish weirs, which I'll discuss in a moment. And then, in addition to those provisions, we have some provisions protecting the hostages from Wales. John had a nasty habit of taking hostages and then killing them or not sending them back. Protecting the hostages from Wales, also promising to deal with Alexander, King of Scots, in the same way that he was dealing with the barons of England. Now, the barons in Wales and the King of Scotland didn't have much to do with the circumstances that led to Magna Carta, but it was smart of the barons and the others involved in this to include them in this because that meant that there were other people who had a stake in this document and made it more popular to be reissued in subsequent reigns, in Henry III's reign and then in Edward I's reign. So Magna Carta reflected a confluence of different interest groups and promoted compromise between those groups. And that is an important reason why it was successful. The second important reason is that it contained specific and concrete guarantees of liberty. If Magna Carta had just consisted of Clause 39 and Clause 40, it would have been a beautiful document that might well have been cited by patriots in subsequent centuries. But it wouldn't have meant very much to people at the time because there's not much you can do to specifically benefit from a clause as vague as Clause 40, saying to none will we sell, deny, or delay right or justice. Because you could make that argument in every case, but it's not specific enough to be of use in any case. But Magna Carta did more than that. And let me give you an example of something that is often invoked in order to make fun of Magna Carta. This is a clause that people seem to find amusing. It says, all fish weirs are henceforth to be removed completely from the Thames and the Medway, and through all England, save at the seashore. And I have heard people mention this to make the point that Magna Carta is not very important. Just look at these silly provisions that don't affect us today. And it's true that fish weirs are not a major concern in today's world, but they were at the time. And what these structures were, they were wooden structures that were built in rivers and other bodies of water so that during high tide, the fish would be caught in the fish weirs. During low tide, you could go out and take the fish. The problem with these things is if you put one in a body of water that was being used for navigation, like the River Thames, which was the lifeblood of the City of London, it is a threat to navigation because the ships have to be avoiding these things. So this provision was very important to the City of London. And even though John did not enforce this provision, the City of London enforced it, the Londoners enforced it themselves. They took these things down. They dismantled the fish weirs because they had the authority to do so under Magna Carta. And for those who think that this wasn't very important, just consider what is happening now in the South China Sea with Vietnam and the United States and China fighting over these artificial structures that are being created on these islands in this area. And what it really comes down to is who's going to control the flow of commerce in that part of the world. So even though we don't have fish weirs anymore, this principle of freedom of navigation is still quite important. And these, here are two other provisions that are quite important to my own research right now. The first is Clause 17, which says common pleas are not to follow our court, but are to be held in some specified place. The second says recognitions of novel disseisin, of mort to ancestor, and of darrein presentment are not to be taken unless in their counties and in this way. The relevance of these provisions at court was for respecting access to justice, ensuring access to justice. King John moved around a lot. His favorite pastimes were hunting and hawking. He liked to hunt wild game and catch birds with his hawks. And to do this, he was always on the move, looking for the best place to engage in these pastimes. And if you had a case before King John, it could be difficult to find him. You would have to figure out where the king is located because he personally presided over some of his cases. And it was difficult enough to have a lawsuit in the royal court if you're coming from a county like Yorkshire, which is quite distant from London and from other places where the king might be. So by guaranteeing that common pleas would be held in a fixed place, Magna Carta protected the right of access to justice for those who had these types of lawsuits. Novel disseisin involved disputes over what we would call possession of property, although that would be anachronistic as applied in this context. Mort to ancestor was inheritance, and darrein presentment was over patronage of churches. And I have more to say on that. How am I doing on time? How much more time do I have? 10, 15 minutes. Okay, good. So, Clause 17 in particular was very important in establishing the principle that there would be a court located in a central place which would hear these types of disputes. And that became the Court of Common Pleas or the Court of Common Bench at Westminster Hall. And Westminster Hall is still there today, and it's used for these ceremonial occasions like when President Obama spoke to the British Parliament. And there's a story that at one point someone suggested that they could move the bench by just a little bit. You know, they were doing some renovations or something, and the Chief Justice said, "We cannot move this bench by even 1 inch because that would be violating Magna Carta. We cannot move this at all." But it was quite important to have this access to justice. Okay, so Magna Carta was important in 1215, It was important enough to a coalition of different groups that it was valuable for the new king, Henry III, who was just a boy when John died, to reissue it multiple times. That was a politically popular decision because the document had specific and concrete guarantees of liberty, and it was of interest to multiple competing groups. So for the rest of my time, I want to talk about the right to trial by jury, why that was important in civil cases in the years leading up to Magna Carta, and why it would have been considered significant enough to warrant a mention, at least indirectly, in Clause 18, which guaranteed that there would be regular access to certain types of disputes. So this is a quotation from the treatise known as Bracton. I won't read the whole thing, but it is talking about the procedure that was used to resolve disputes over presentation to churches, and that these disputes would be resolved by convening a group of regular laymen who we would refer to as a jury. And what this was dealing with was, you can't really see in this, but this is a picture of a church in the English Diocese of Norwich. The right of patronage to a church was an extremely valuable property right in medieval England. Whoever controlled the right to present a priest to be the candidate of this church would be assured of having many young, literate men willing to perform services for that person, like engaging in correspondence with bishops, with other nobles, with the king. So it was quite valuable to be the patron of a church and have the right, what they called the advowson of the church. Because it was so valuable, there would be disputes about it, and these disputes could take different forms. It could be a dispute over whose ancestor had presented the last parson, or whose ancestor had the right, if there's a dispute between two neighbors. Or it could be a dispute involving a gift to a monastery, and I'll talk more about how those kinds of disputes could come up. But it was quite important to King Henry II, John's father, that these disputes occur in the royal courts, not the ecclesiastical courts. As you know, King Henry II had some difficulties with one of his archbishops of Canterbury, Thomas Becket, who is now St. Thomas Becket, and is the reason why people went on pilgrimages to Canterbury. So he had a bad experience with the church. He had a difficult relationship with the church. And he wanted to make sure that he and his courts would control these types of disputes. But the bishops were quite happy to hear these types of cases. They would like to have the power that comes along with arbitrating these important disputes. Moreover, the bishops had literate clerks who were working for them that would be capable of going out and conducting investigations and taking written depositions in the inquisitorial style to resolve these types of cases. In addition, of course, they had a sophisticated body of canon law that provided answers to some of these disputes. So in order for King Henry to persuade litigants to come to his courts, which he insisted had jurisdiction over these cases, he had to offer something that was better, at least for some litigants, than the system of justice that was available in the ecclesiastical courts. Because if both parties to the dispute were happy with the justice that they could get in the ecclesiastical courts, then there would be no reason why they would want to go to the king's court, when it was more difficult to find the king's court, whereas the bishop is going to be closer to where the dispute is happening, and had a efficient and legitimate way of resolving these cases. So Henry had to appeal to some litigants in order to get them to come and try his system of royal justice. Because it was under Henry, as you know, that the common law developed, that these new writs were being created to bring people into his courts. So what I'm working on now in the research for my book is trying to look at these cases from a quantitative perspective and see if I can figure out who is bringing the very first lawsuits in the royal courts and why were they attracted to those courts as opposed to the ecclesiastical courts. This is not a very well done slide because the color scheme these two colors are quite similar to each other. But what this is showing here, this is a graph of a chart of the distribution of cases in the very earliest surviving royal court records among the different dioceses of England in disputes involving advowsons of churches. And what I found is that in the Diocese of Norwich, there are many cases being brought, and they're almost all being brought by laymen against other laymen. So it's some kind of dispute over whose ancestor has the right of advowson. But in the Diocese of Lincoln, most of the cases involve laymen who are suing monasteries, religious houses. And why would this type of dispute be more common in Lincoln? The way that these disputes would come up was typically in a situation where the layman who last presented the priest to be the parson of the church had made a gift to a monastery. His son is now trying to claim the advowson because he wants to have the power that comes with the patronage that the advowson provides. And the son is suing the monastery, claiming that this gift either didn't occur or that it was invalid for some reason, like if the ancestor lacked the capacity to make the gift, or if he revoked the gift because these gifts were treated as being revocable. So why were these cases coming out of the Diocese of Lincoln specifically and not out of these other dioceses? There's just one case from some of the other dioceses when Lincoln has 7 of them. Well, this is where it's helpful to know a little bit about the Bishop of Lincoln. Because the Bishop of Lincoln in the year 1194 was Hugh of Avalon, who has also been subsequently canonized, but who was a little bit smarter than Thomas Becket because he managed to get canonized without being murdered, which I think is a superior outcome for a medieval bishop. But he was a holy man, just like Thomas Becket. He had been a Carthusian monk, then a prior of after serving in the Grande Chartreuse monastery, that was the head monastery of the order, he became a Carthusian prior in England. The story as to how he became the Bishop of Lincoln is that Henry II was crossing the English Channel in a dangerous sea voyage, and Henry prayed to God that if God would only bring the ship safely to the other shore, he would agree to have this holy man installed as Bishop of Lincoln. Because otherwise, this was not the type of bishop that Henry liked. Henry liked bishops who were compliant bureaucrats, not holy men. But Hugh became bishop. Now, if you can imagine yourself as a litigant with a dispute against a monastery, a layman with a dispute against a monastery, would you want to have the holy man, Hugh of Avalon, arbitrating that dispute when you know that the monastery is going to bring in this beautifully written charter and say, why did your ancestor, now that your ancestor gave us this, and now you're claiming that you should get it back? Well, I think the layman would be skeptical that they would get a fair trial before someone who was so sympathetic to monasteries. So that is the reason why I think you see so many disputes of that nature coming up in his diocese in the royal courts, where they will find a different kind of justice. And that's just a hypothesis, of course, but I am finding that as time goes on, when Hugh is no longer the bishop, you see the cases following a broader distribution and not being so concentrated in Lincoln. And my theory is that over time, the common law courts become the default mechanism for resolving these cases for everybody, and there is less interest in forum shopping between the royal and the ecclesiastical courts. Now, the relevance to Magna Carta is King John was frequently presiding over his royal courts, relative to his older brother Richard, who was almost never in England, and his father, who had more important things to do. Although in most cases, John didn't say anything. He just allowed them to proceed the way they were supposed to. Occasionally, John, while he was presiding over his court, would intervene in some way in a case. So for example, in 1201, King John orders that a particular case is to be postponed because he's trying to make sure that his preferred candidate is elected Bishop of Lincoln, Hugh of Lincoln having died several years before. In 1203, he dismisses another lawsuit because this time the bishop is his best friend, his closest advisor, John de Grey, the Bishop of Norwich. He doesn't want this person to be troubled by this litigation. And then my favorite example, I'll skip over this. The favorite example is from 1207. The lawsuit is dismissed because Dominus Rex non vult quod loquela illa proceda. It just doesn't want the lawsuit to proceed. So you can see him here delaying justice and denying justice. You don't see him selling justice, but there's evidence that he did that as well. So given the importance of these lawsuits to the layman who wanted this patronage, and given how valuable trial by jury was as an efficient and respected way of resolving these cases, you can see how John's interference, which threatened to push people into the ecclesiastical courts, would have been a concern for the barons who were present when Magna Carta was sealed and were responsible for much of its content. So, to sum up what I've been saying, Magna Carta was important in 1215. It was important for reasons that remain important today, even if the specific content of Magna Carta has become less significant. And one of the things that it's important for is for guaranteeing access to justice in certain types of cases, and that has formed a foundation for the rule of law as we know it today in many countries of the world. So thank you very much, and I invite your comments and questions. Thank you.